السلام عليكم أعزائي المشاهدين الكرام، أهلا وسهلا بكم في بث مباشر من برنامجكم ضيف جنى. هذا البرنامج جاء ليكون حلقة توصل بين أعضاء جنى كافة تحقيقا لأهداف جنى ورسالتها السامية. نطل اليوم عليكم في حلقة جديدة من برنامج ضيف جنى، لكن قبل أن نتحدث عن حلقة اليوم أود المرور سريعا على أهم مواضيع التي أثرناها في الحلقات السابقة. تحدثنا سابقا عن مؤسسة أو منظمة جنى ماضي حاضر ومستقبل. تحدثنا عن كل ما يتعلق بالقبولات في الجامعات الأمريكية والكندية والأسترالية. تحدثنا عن طرق التقديم لهذه الجامعات، مراسلة الدكاترة وأيضا تحدثنا عن المنح الجامعية. تحدثنا عن مزاولة مهنة الصيدلة والهندسة والمهن الأخرى في الولايات المتحدة الأمريكية. اليوم سنتحدث عن موضوع آخر، ويسرنا أن يكون معنا في هذه الحلقة الدكتور محمد المصري. دكتور محمد المصري سيكون ضيفا عزيزا ومقدما للبرنامج. في الأشهر الماضية انقطعنا عن تقديم برنامج ضيف جنى لأسباب شخصية، وارتأت إدارة جنى أن يكون الدكتور محمد المصري معنا في هذا البرنامج لديمومة بث هذا البرنامج وتقديم كل ما هو مفيد للطالب الأردني وللخريجين الأردنيين. الله يعطيك العافية دكتور محمد.
أهلا وسهلا يا سيدي، الله يعطيكم العافية.
دكتور محمد راح يكون معنا اليوم، راح يقدم ضيف حلقة اليوم. تفضل دكتور محمد.
alright. شكرا جزيلا دكتور عبد الله. يعني أعتقد إنه ممكن تدخل عليه الآن الدكتورة لينزي هاريس هتكون موجودة. Okay. Hi Lindsey, good to see you.
Hi, thanks for having me today.
Thank you very much for being with us. So as I mentioned on Jena website a few times, that we are actually very grateful to have Dr. Lindsey Harris tell us, the community, the Jena community, everybody interested, on possible pathways leading to, being able to immigrate to the United States, mainly through job or through, for professionals, etc. So what I will do is that I'll briefly introduce Dr. Lindsey Harris, and then she will have the floor to pretty much do her presentation, and then we will go into a session of questions and answers. And I have received a few questions from a good number of Jena community. So we have that in some kind of slideshow, so we will go through that. And we hope to be able to finish this maybe within an hour plus minus, depending on how things go. So Dr. Lindsey Harris is the founder and managing attorney of Shoreline Immigration. Shoreline Immigration is a full-service immigration law firm located in Houston, in Texas. Lindsey, an immigration attorney licensed in the state of Texas since 2014. She holds a bachelor's degree in sociology from Texas A&M University, a master's degree and a PhD in Juris Doctorate, that is, in law, from St. Mary's University. Prior to beginning her career as an immigration attorney, Lindsey was also an analyst, specializing in the Middle East and North Africa global regions. So she provided in-depth research and risk analysis for international corporations with assets abroad, pretty much in the private sector. And Lindsey lived also in Egypt for a year from 2011 and 2012. And while there, as you might know, there was the Egyptian elections, like the historic Egyptian elections 2012. And Lindsey participated as an international elections monitor. She also participated in legal study program in Palestine in 2010. And all of these things, of course, add to her unique skill set and knowledge in international relations and international law. So without further ado, again, we're very grateful to have you, Lindsey, here. The floor is yours. Please go ahead and, feel free. I don't know how much time that's going to take. We said maybe 20, 25 minutes. and then we will get into the question session. Thank you.
Yes, sir. Thank you so much for that introduction. Special thanks to you, Mr. Al-Masri, for helping organize this, Dr. Mustafa Asala, and also Dr. Abdullah Friwan. Thank you so much for having me. It's my pleasure to speak with you today. So just a little bit, you did a lot in covering what we do at my law office already, but I'd like to briefly touch on the services we provide as an immigration law firm. Firstly, we handle family-based cases, citizenship, permanent residency, employment-based immigration, deportation defense, if anyone should find themselves in the immigration court system. We also handle asylum, investor visas, and all types of humanitarian relief. So when we say a full-service immigration law firm, we pretty much do it all. That's why I'd like to cover a lot of topics briefly today, just to give you an idea of what's out there as far as immigration options. I'll split those into two segments. The first will be dedicated to employment-based options. That means you have an employer sponsor who is willing to go through the immigration process with you as your sponsor. The second half will be dedicated to alternatives to that, including a national interest waiver where you're self-sponsoring, and some different family-based and investor-based options. So without further ado there, let's go ahead and jump into your employment-based options. I know that many people in the audience today are going to be professionals in various fields, nursing, architecture, engineering, computer science. So I really wanted to focus on the most relevant options for you. Well, I'd like to start with the PERM labor certification process. If you haven't heard of PERM or the labor certification process, it's generally thought of as 4 to 5 steps, where you have an employer who is willing to sponsor you for permanent residency or a green card. Okay. And if you do find an employer who's willing to sponsor you, the first step would be for them to accomplish labor certification. That would require them to post the job that you're actually being hired for, to see if there are any qualified U.S. workers. The objective here is for the U.S. government not to knock out any U.S. citizens from the job that you're trying to apply for. So if they post that job, no qualified applicants come forward, or if they do interview people, but they're not fitting the bill for some reason, they can move forward with the prevailing wage determination. That is something that's filed with the Department of Labor, and that's where we make sure that U.S. employers are not undercutting wages for foreign employees. We don't want a situation where any employers are taking advantage of foreign workers by offering less than they would offer an American citizen. So the wage determination process is really important. The employer also has to go through that. And once they get through these two important hurdles, they would be able to start sponsoring you. That includes filing an I-140 petition. Now, this I-140 petition is much like a relative petition in a lot of ways. It's basically some U.S. entity or sponsor saying that there is a relationship with this person, in this case, employment relationship, and that they have met all the qualifications for the job being offered. Now, this petition can be either filed separately or together with your green card application. So potentially, applicants could have a way to be here in the United States legally at this point in the process if they choose to file their green card application at the same time. However, a lot of employees may be either overseas or they want to see if the process plays out favorably first before they actually file for their green card. So that is the PERM labor certification is a really good option if you have the opportunity. It is sometimes difficult to find an employer who's willing to sponsor and to foot the bill for the first half of that process, because they are required to. You as a beneficiary aren't actually allowed to pay for the first 2 steps. You can only pay for legal services and filing fees at the I-140 petition stage. This is a great option for nurses and physical therapists. The reason is they get to somewhat bypass the first step, which is posting that job application, waiting for the labor certification to go through. They can just jump straight to the prevailing wage determination and jump right into the petition itself. So that's why a lot of nurses and physical therapists are are easily able to get their green card and also much faster than other categories. This typically takes somewhere between 1 to 2 years. It's a long time. So anyone going through this process needs to make sure that they are maintaining a status inside the United States while this is playing out, or if they're abroad, they would be getting a visa at the end. But for nurses, this is going to go much quicker. That first step takes probably 5 to 6 months because they're able to bypass some of it. And then we're looking at another little while for their petition to go through. I would say within a year, they would be able to get their green card, most likely. Moving on past perm labor certification, I wanted to speak briefly about the H-1B. I know most of you are probably very familiar with this category. It's in the news a lot. We've all, heard or know somebody who's gone through the H-1B process for specialty occupations. There was a question that I received before this about, certain job categories that may be more popular or, more successful in going through the immigration process. What I would say a good place to start for that, go and look online through USCIS at H-1B specialty occupations. And there's going to be a pretty significant list there of occupations that are qualified for the H-1B and popular choices out there. I'll read off a few. Professors and teachers, engineers, healthcare workers, financial industry professionals, accountants, architects, market research analysts, doctors, nurses, dentists, the list goes on. So the H-1B, there's a lot out there as far as H-1B, but as you know, it's also called fondly the H-1B lottery. And the reason it's called a lottery is because the H-1B every year only has 65,000 visas available, with another 20,000 added on top of that for people with master's degrees or higher. So the H-1B is limited each year. That's why you have to throw your name into the lottery system and see if you get selected there. There are some professions that are cap exempt. So they're not limited to that number of 65 to 85,000, however you look at it. And those would be members of or employees of nonprofit organizations and research institutions. So they don't have to wait on the filing window that happens generally the first couple weeks in March. They're able to submit applications year round, and they're not in that specific lottery system. So H-1B is a popular option. It's not necessarily guaranteed to work out because of the lottery nature of it. And it's also not a permanent option like the first one we discussed. H-1B is typically maxes out at about 6 years. But during those 6 years, you would be able to find an employer that could sponsor you permanently. And then you could change over to the perm process. That's what a lot of people end up doing, or various other options to stay here permanently, but not directly through H-1B. One of the other categories I wanted to briefly talk about would be the O-1. The O-1 visa is basically for you should think of it as an extraordinary ability type visa. It is also non-permanent, so it doesn't lead to a green card, but the cool thing about the O-1 is it's renewable indefinitely in 1-year terms. So it does require a job offer with the sponsoring employer. There's not a limit like the H-1B, so you're not in a lottery situation. It's based on extraordinary abilities in the sciences, arts, education, and business fields, as well as athletics. You can also have your spouse and children under 21 get the O-1 visa. So just for your information, I'm going to read off some of the eligibility criteria for the O-1. And if you meet 3 out of this list, you may be eligible for the O-1, and we would be more than happy to talk to you about that, or any attorney of your choice. If you're working with an attorney, if you think that O-1 sounds like something you may be qualified for, you should speak to a legal professional about this. So here are the criteria. Receive nationally recognized prize or award for excellence, attain membership in a professional association, been the subject of published material in a professional or major trade publication or media network, participated on a panel, either individually or as a judge for the work of others in your field, made an original scientific, scholarly, or business-related contribution of significance in your field, authored scholarly articles or published in journals for major media, been previously employed in a critical or essential capacity for an organization of distinguished reputation, and have or commanded a high salary for your field. So this high salary requirement is interesting because what you can do is see what the average salary is for that position. And if you're being paid well beyond that, that could be a reflection of a really high skill level. And that can actually be used as one of your 3 criteria meeting requirements. So O1 is a great option, prestigious type of visa, and it's one some people don't know about. The last employer-sponsored category I want to talk about today would be the L1. L1 has 2 subcategories. All right. So L1 is for intra-company transferees. That means there's a business abroad, a foreign corporation or company, and they have a branch inside the US, or they're starting a new office in the US. If you are a manager or an executive in that type of company that's forming a subsidiary in the United States, or if you're a essential specialized knowledge worker in one of those companies for a year or more living abroad, you may be able to transfer to work in the US based on the L1 visa. Now, this one also is not a permanent residency category. That would give you a maximum of probably about 6 years on the L1. Okay. Now, everybody, please don't feel like you have to memorize all of this. We're going through this relatively quickly. There's tons of visas out there, and we're just going to do our best today to inform you so that you can make the right decisions in your professional career to see if you want to stay in the United States. So moving on from that, let's talk a little bit about non-employer sponsor categories, okay? I want to start with a related one. It's called the National Interest Waiver. National Interest Waiver is very similar in a lot of respects to some of the ones I just mentioned. However, you are asking for a waiver of the employer sponsor requirement. That's why it's called the National Interest Waiver, because you're saying that your skill level and your contribution based on your occupation is so great to the national interest of the U.S. that you should not have to require an employer to sponsor you. So this is really going to be based on your own merit and your own creativity in a lot of ways. So the National Interest Waiver is a really good option for those of you who may have a master's degree or higher, or the equivalent of a master's degree, which would be a bachelor's, and 5 years experience can be an equivalent. Okay. So if you have that baseline, you can go on then to prove some of these categories, which I'm gonna read off to you. They're similar to O1, but there are some minor differences. So if you want to apply for the NIW, you need 3 out of these 7 eligibility categories. You need to show your official academic record showing that you have the requisite degree, letters documenting at least 10 full-time years of experience in your occupation. That's one option. A license to practice your profession, evidence that you have commanded a high salary, once again, membership in professional associations, recognition of your achievements or significant contributions to your industry in your field by your peers, government entities, or professional organizations, and other comparable evidence. Now, I'll tell you some of the most common things we use for NIW, which we get a lot of at our office, would be letters of recommendation from people in your field. Proof that you were a presenter at special conferences, that you are a trainer, that you have the high salary, and things of that nature. So if you can provide 3 out of 7 of those things, you're on your way to NIW. Now, one of the most important parts of NIW that is not required for the employer sponsorship is the waiver itself. And the way you get that waiver is showing that your proposed endeavor, your plan for your contribution, is in the national interest. And the way you do that is showing that it has merit, it's in the national importance, that you're well positioned to make it happen. So, for example, if you have the funds or the networking, or you have contracts in place to make this plan happen, and that on balance, it's going to be beneficial to the United States. And potentially create employment or something that's in the national interest. So a good example of an NIW career would be, for example, a petroleum engineer, who has created patents that are more environmentally friendly or more efficient. Those patents can be used as examples of the eligibility criteria. If that person had published articles about this new way of drilling or fracking that is more environmentally friendly, that's clearly in the United States' interest. You can find all over government websites how we're trying to improve green technology and reduce carbon emissions. So somebody like that would be a really great candidate for the NIW. It's definitely not limited to engineers. There are all different backgrounds that can apply for NIW: professors, scholars, researchers, biology researchers, people working on cures for cancer, COVID research, all these types of things. Really, the sky's the limit with the NIW. Just the very important aspect of this is going to be your personal statement explaining what you're planning to contribute and being able to prove how that's in the national interest. And, we would love to talk to you about this. If you have specific questions, either with us or your attorney of choice, NIW is a good option. And that does lead to a green card, by the way. It is a permanent residency option. And so it's a highly interesting category. There's also, of course, the EB1 extraordinary ability that doesn't require an employer sponsor. This is similar to the NIW, except the bar is much higher on the extraordinary ability side. It doesn't have the national interest component, really. This is more for like Nobel Prize winners, people who are at the very, very top of their field, and it's not arguable about their ability to contribute. So these are few and far between, I would say. NIW is much more realistic for us normal people rather than the Nobel Prize winners out there. Okay, so those are the main directly employment related categories. You don't have to have a sponsor. One of the things I know is of interest to this group, especially being mainly Jordanian citizens, is going to be the E2 investor visa. Of course, E2 investor visa does not require an employer. It honestly requires you to be an employer. So the E2 is available to nationals of about 82 different countries who have a treaty with the United States. Okay, so if you are a citizen of one of these 82 countries, Jordan is one of them, you would be eligible to apply for the E2. Now, you can do the E2 from abroad or here in the United States, okay? If you're doing it from abroad, you're going to get a visa and travel to the U.S. If you're doing a change of status here, you would be simply become an E2 status without the visa, okay? So the E2, in a nutshell, it is for investors who want to start any type of business, any legal type of business in the United States that contributes to the economy, has the potential to hire workers, and just generally, any legal functioning type of business is okay. Now, a lot of people will ask me, can I invest in real estate? Can that be an E2 investment? And the answer is probably no for something like that. And we'll talk about why later on. The E2 process itself consists of sourcing your funds, which means determining the origin of your money that you're going to be using for your investment, coming up with a business plan, investing those funds into your company, and then applying for the visa. So you have to put the cart before the horse. You have to go ahead and invest that money and then apply for the visa, because your money does have to be at risk. Now, how much do you have to invest? That's a great question, and it's not one that's answered by the immigration laws. There's not a minimum amount, which is really great for investors who may have, $50, $100, $200,000 to invest, and they're not going to be qualified for the EB5 Golden Citizenship Visa, which requires $800,000, not to be confused with that one. The E2 does not have a required minimum amount for your investment. It's going to be proportional to the type of company you choose. I always like to give the example of two different types of companies and what those investments could look like. If you have a digital marketing company, you need a laptop, you need a virtual address, you need a marketing budget and some software. You might be able to get away with $20,000, $25,000 in investment for that. That's risky. That's kind of low, but that's on the low end. On the more Higher end for E2 would be, for example, like a used car lot. If you want to resell automobiles and you want to set up an office and do that, that's going to require inventory. You're going to have to buy the vehicles, purchase the shop or lease, get all your licensing. That's going to be more like a $400,000 investment, right? So the investment amount is directly related to your business and how much it's going to cost to open the doors to that company. Okay, so that's E2. E2 is generally granted for 2-year increments, and you can renew that indefinitely. So as long as your business is running and you have your E2 business going as according to your business plan, you should be able to renew that either at an embassy or inside the United States. And of course, your spouse and your children can be dependents on the E2. And one of the greatest, things about the E2 is your spouse will have work authorization. So generally, people will choose to have the E2 investor put in the name. The E2 investor primary will be in the name of the person who doesn't want to work outside the company. So if your spouse has a high earning potential and they have an employer that they want to work for in the U.S., they can do that, and you would have 2 incomes, one from the E2 business and one from your spouse's employment. So that's really helpful. All right. I'm sure, we may have some more E2 questions, and I can go into that in greater detail probably at the end when we do the Q&A. But moving on from the E2, I briefly mentioned the EB-5, citizenship by investment. That was recently reauthorized. That program is often in limbo. People don't know if 1 year to the next, if it's going to be renewed, but I believe they just renewed it for 5 full years. So the EB-5 program is just what it's called, citizenship by investment. What you do is you invest $800,000 into either a regional center, which acts as the middleman for large scale projects, or you can start your own company for that $800,000 and get a green card through the EB-5 program. All right, that's pretty much it for investment. What I'd like to do is talk about family briefly. In case any of you have family law questions, I'll go over some family based immigration solutions, and then we'll talk about J-1 waivers and asylum at the end. Okay, so let's see. The family-based options are very interesting because these are usually the most straightforward immigration pathways for people, but they're also totally by chance. Did you meet someone who's a U.S. citizen and get married? If the answer is yes, you may have a really strong case for a green card. Do you have a parent who's a U.S. citizen or a child who's over 21 and they're a U.S. citizen? They could sponsor you. So family members, including parents, spouses, and kids under 21, those are considered immediate relatives, and usually a visa is immediately available. If we're talking about children over 21 or those who are married, brothers and sisters, or family members of permanent residents, not U.S. citizens, those are in preference categories, and the visa wait time can be a little bit longer for them. But I would say most immigration statuses in the U.S. can be converted into a family-based petition, except for J-1 that are subject to the 2-year rule. And with that, I will go into the J-1 and the 2-year rule, because I know probably many of you out there right now listening may have the J-1 exchange visitor visa, and you may have the 2-year rule, the infamous 2-year rule. So J-1 exchange visitors are in all different categories. They come here for all different reasons as a cultural exchange program. So you bring your knowledge and your cultural experience to the U.S., and in return, you go back home and you share what you learned in the U.S. with your home country, right? And sometimes this is very formalized on your visa, and it's called the 2-year requirement, or I-212E, the 2-year rule. Okay, and that means that you, upon completion of your J-1 program, would have to return back to your home country for 2 years before you're eligible for a change of status or adjustment of status in the U.S. There are some exceptions to that. Those are pretty limited. But what I'll go ahead and do right now is talk about waivers of the 2-year rule. And if you're interested in staying in the U.S. without going home and completing that 2 years abroad, you may be able to get a waiver of that requirement. Now, there are 5 general ways to waive the 2-year rule. Let me read those off, and then we'll take them one by one briefly to explain. The first way, and the easiest way, I like to say, would be the no objection statement. No objection statement is a letter from your home country, the embassy in the United States of your home country, so Jordan, would issue a letter saying that they do not object to you foregoing the 2-year residency requirement. And you can generally get those if you did not receive government funding from your country or the United States, or if you're not a physician. So if you didn't receive any scholarship funding for your J1, if you're not a doctor, you may be able to do the no objection statement. I've also seen from my own practice, clients who did receive funding from their government and they agreed to pay that back, kind of on the back end with their government. They made a deal, they repaid the scholarship money, and then their government released them from the 2-year rule with a no objection statement. I don't think that's going to be possible if you got U.S. Department of State funding or U.S. government funding from another department. That's probably not going to work out, and you're probably going to have to go with one of the other options. But J1, no objection statement, by far the most straightforward J1 waiver available. All right. The second way would be a request from an interested federal agency. So if you have a U.S. government agency who values your research to the extent that they would be willing to almost petition for you to write a letter and say that we need this person here, that's one option. Another option would be fear of persecution in your home country. So if you don't want to return back for those 2 years because you fear that you're being threatened for any reason, you are fearful of your government or from groups within your country that the government can't control or they can't protect you from, you could file a persecution waiver. And I would think of that as kind of like a mini asylum case that's built for your J1 waiver. All right. The fourth way would be hardship to a U.S. citizen, spouse, or child. So if you're here in the U.S., you are married to a U.S. citizen, you have a U.S. citizen child, and you believe that the requirement to go back to your home country for 2 years, either with your family or leaving your family here in the U.S. behind in that separation, if you believe that that would cause a hardship to your family member that's a U.S. citizen, you can apply for a waiver based on that. Now, it has to be more than just the family separation. It would have to be something along the lines of loss of employment or career opportunities, lack of education potentials for kids, health concerns. Perhaps there's not medical treatments available in your home country that your family member needs if they have a rare or chronic health problems. That could be grounds for a hardship waiver. And then the fifth option is the Conrad 30 program for physicians. This only applies to foreign medical doctors. And generally, your program will handle this for you. So I'm not going to go into that too much. It's related to service in a hardship area for a certain amount of time. So doctors are eligible to get a waiver based on that. Now, the last thing I want to discuss would be asylum. That is one option that we also offer in the United States is protection for people who fear returning to their home country. I'm not sure if this would apply too much to any of you guys. You would be applying for asylum based on not wanting to go back home for some reason. This can vary considerably. We do affirmative and immigration court asylum cases. If you are to win an asylum case and be labeled as an asylee, you would be able to get permanent residence after 1 year, and you would get citizenship after 4 years later. So that's a very important point. We want to make sure that everybody out there, whether it's you, friend, family member, colleague, anybody who is fearing threats back in their home country, we want them to know that is an option, and we're here to help with that. So I know that was pretty quick. I'm right at about 30 minutes on my talk. It's now about 12:35. So what I'd like to do is turn this over to Mohammed for question and answer. He was kind enough to give me some pre-written questions that you guys received before this. So I'm going to have those in front of me as well as wait for you to read those out so everybody can hear.
Oh, wow. Thank you so much, Lindsay. I mean, this was very, very informative. I consider myself a bit educated about immigration law, and there are so many things that I learned about for the first time. I didn't know about these details. I didn't know about O1 visa and EB1 visas. I had no idea. L1 visa. First time I hear these guys.
Yes. Yeah. Thank you so much.
I didn't know. I mean, this is really very informative. Thank you very much. Look, I have here the pretty much a few slides with some of the questions, and you've already answered some of them. So the questions that you have answered, we just going to go by them through. I mean, just going to probably skip them unless there are like specific details you want to know about or you want to add. And please, for our audience, is that all of these questions are going to be available, and the contact information with you and your office will be posted on Jannah. So we discussed the E2 investor visa, and the thing that I did not learn about there is that I thought that was like there was a minimum, pretty much sum of money, $500,000. That's the number that was in the back of my mind. I don't know where I got the number.
Yes.
But I thought it was like $500,000, and I said, who's going to be able to do that? I mean, if I have $500,000, I can go to Mauritius.
Yes, I know where you got that number from. It was the old EB5 number. So in the past, the EB5 citizenship by investment, their old requirements was 500,000 if you're in a targeted employment area and $1 million if you're not. So that's what people think about a lot when they think of the investor visa, which because it's a really popular category. But it does have that minimum threshold. But like I said, the E2. The lowest I've personally seen is 15,000. We did a renewal. We didn't do their initial, but it was an Australian family, and they came over investing only 15. Now, most of our clients do not invest that amount, and we don't, advise that. Usually, ours are closer to, I would say, 50 to 150,000. So let's say 100,000 is a really good round number to focus on, and that's adequate for most types of businesses.
The idea, I mean, the business idea would be actually a big factor. I'm assuming, I'm not into businesses, but I would assume that a good business idea with a little bit of capital would actually be very helpful for so many people. For sure. That's great. So we're going to move to the next question, to the next one. So based on the questions or the cases you deal with, your office deals with, you discussed this, but what do you think are like the most kind of prominent types of jobs, the things with most potential? I know nursing is like on top of these ones, and you mentioned something about nursing that they can kind of bypass some time requirements. One thing in nursing is that a lot of those medical professions that they have to have some kind of certification. I know all states require specific like licensing. So if, let's say, a nurse in Jordan, so to speak, wants to apply to some kind of job, do they have to be licensed in the United States in some state here, or they can do this later? How does this work?
Yes. So they do. A lot of people will do this by coming to the United States, for example, as a student and starting and working on their nursing requirements. A lot of doctors do this too, taking the U.S. medical licensing exam, getting those credentials down. So if you did that in the United States, you took the nursing board exams and everything that you're required to do. You're required to show that you did, an English language study program for nursing. So all of these things that are required for specific occupations, you could do that abroad potentially, or you could do that here in the U.S. As a student. And then if you're here as a student, you have a seamless transition to go right into the job sponsorship if you can align your timeline correctly. So, there's a lot of people that can do that. Or, for example, if the employment process is taking too long here, you may have to exit and re-enter under that new visa category, just making sure you don't ever overstay a visa, you don't ever fall out of status. That's probably the most important thing. But regarding the the top professions for immigration. Nursing is one of them. I know that if you go and look at the specialty categories for H-1B, that can give you a really good idea just off the top what kind of professions are in demand, what they call specialty categories. The only one that I'm aware of right now, they may update this sometime, that's called the Schedule A would be nursing, physical therapist, and a really obscure category called sheep herders. I've never had a sheep herder client, but that's an interesting one. I think I'm going to have to take a deep dive and research what that entails. But I don't think anybody here is going for that. So I would look at the H-1B specialty occupations, nursing, anything for NIW can go, but the most in demand would be what you see in the news. So if you hear a lot of talk about environmental strategies, disease, COVID control, cancer research, these type of hot topics that you're hearing a lot about, those are always going to be in demand for NIW because you can correlate what's being asked for by maybe the president's office themselves. They issue statements, we need this to improve our country. You can use that type of stuff for your NIW. And we will typically do a pre-qualification screening for NIW candidates. So you tell us what your goals are, what you currently have, and we'll tell you if you're ready or if you need to work on some things. And we'll give you our recommendations for what you can do to build up your skill level to be qualified. Oh, sorry, I can't hear you, Mohammed.
Yeah, I muted myself.
Okay.
That part about like when the market becomes saturated, I know, everybody has to be pretty much following the market, but the market in the United States has always been in dire need for pretty much most of those professions in the medical part. So
yes, definitely.
That's not a bit, but the sheep herder thing is really interesting.
It's mind blowing. Yeah. we need to do another webinar just on that.
Look, it makes sense because during the COVID pandemic, we had lots of problems with the chain supply. Pretty much, meat was a big demand. It still is. So things are crazy, but yeah, it makes sense. Okay,
certainly.
This is another thing about the areas that are pretty much in need, but not so. Like people don't know so much about them. I know that there is a huge need for truck drivers, like plumbers, electricians. Are these paths that can pretty much go under an IW or any other type of visa, or you think this is kind of not related so much?
This one probably not NIW, because NIW requires a pretty high level of acclaim and showing that you are a really special type of snowflake in your industry. A lot of people are willing to write letters for you and things like that. So these type of really essential workers that we need here in the US, those are probably going to be a traditional EB3 category for skilled workers who need an employer to sponsor them. So if you remember, one of the first topics I covered today was the PERM labor certification process, where you prove that there's no U.S. workers to do the job, that you show the prevailing wage, and then you can petition. So that's probably going to be the pathway for these folks that are in these areas, but it's definitely possible.
Okay, great. Yeah. The good thing is that lots of these things are flexible. And I can tell you that the stereotype in the mind of so many international students, so on people, including myself, is that lots of these things are kind of like, they look like lottery based. Like I do everything that's required, but I didn't get it. And I know, having lived through this, that there is actually a process, and there are things that maybe applicants don't know about directly. They cannot get specific answers on very specific questions, but at least we need to put applicants, I believe, should put the work.
Yeah,
whatever they want to do.
And it is complicated. I mean, when you're talking about 100 different types of visa categories and 25 steps for each category, it's hard to not know exactly what to do. That's why every case that we have at our office, and most lawyers are the same way, we start with a detailed 1 hour one-on-one consultation with you. So we get all of your facts. We know what's important to you and your family on your timeline, and we can really narrow that down. And at our office, once we narrow down, I would say anywhere between 1 to 3 categories that somebody is qualified for or may be qualified for one day, we'll send an overview sheet with the process steps so that you can know what to expect, what's coming, because this is complicated.
Okay, yeah, great, wonderful. All right, so one thing is, getting people pretty much to prepare for their application. So if, what are the things that you think are generally very helpful for people to bring or to prepare a strong application? So if someone is planning to apply, let's say, through one of those categories in 3-4 years, what are things they need to be doing or watching as they come through the process?
Okay, so let's talk about maybe the employer sponsored one, and then I can talk a little bit maybe about an NIW type situation. For the employer cases, the most important thing, the thing that you can control is your reputation in the company, making an employer HR department want to come off the money to sponsor you because they have to pay for it. And they can't really ask for that back. So we're talking about, $5,000 to $10,000 investment into an employee, and you want to show that you are a good employee, you're dedicated, you're loyal to the company. They don't want to sponsor somebody and they immediately leave right after they get their green card. So I would say just those soft skills involved in your day-to-day interactions with your employer, be that person who they want to go the extra mile for you because you've gone the extra mile for them. Right. So that's number one. One kind of more tangible thing you can do is go into a profession and try to achieve a job title that's going to correspond exactly with what they need for the position. Now, a lot of times your employer will actually modify your title to match a position that looks good for the labor certification. Okay, so they may change your duties, they may change your title, and just be willing and be flexible to do what you need to do for the sponsorship. Now, it's usually not that much different, but I have seen cases where people need to shift course a little bit, and go into a field that's more likely to be sponsored. And that varies by industry. It's kind of impossible for me to say what that is. It just varies by company and by industry. The main bottom line for everybody here is to make sure you do not overstay your visa. You don't have, criminal convictions can affect your case, even minor ones, unpaid tickets, things like that, arguments with family members, any police, domestic violent calls. Those type of things can really put stress on your immigration status. And, it makes it harder. It doesn't make it impossible, but I would say, any interactions with law enforcement, visa overstays, things like that would be important to avoid. Now, I mentioned a little bit about NIW. What I would do if you're interested in one of these types of cases, look at the requirements, look at the eligibility and say, okay, I can meet 2 of these, but I don't have the third one. Let me start joining these organizations. Let me see if I can be a panel speaker. Let me see if I can start working on articles that I wasn't planning on publishing, so you can pre-qualify yourself, really.
Yeah, that's a great. Yeah, I understand. It takes time for people to get into this mindset that you plan to do something in 5 years, start working on it from now. Because there are things like when I look back at things that I not did things happen. Right.
Yeah.
I say I wish I actually paid that thing on time because it shows up. I don't know now. Then you become kind of worried that is this going to affect my application or not? This thing you can actually avoid.
Exactly.
And one thing that I agree definitely with you is that any problem with immigration, like any overstay, is going to impact the application really, I would say, negatively. So
100%. Yeah. Anytime you get an overstay, so let's say you overstay for less than 6 months or up to 6 months, you're going to have potentially, actually it's 6 months to a year, you're going to have a 3-year bar to re-entering the United States. If you stay over a year, you have a 10-year bar to re-entering the United States. So in all those situations, even if it's less than the 6 months, you're still probably going to have a waiver, showing some sort of hardship to a relative or some reason why it was beyond your control. You don't want to enter into that unless you absolutely have to.
Okay, great. I think, look, we kind of answered this, but I don't know if there's anything missing that we need to add. But so I got like a few case studies. I told you about those questions. That this is my case. So I try to lump some of them in cases that can maybe benefit like a general audience. So this is like question. I'm an undergraduate majoring in, let's say, computer science, and I want to eventually be working and living in the United States. What are things that I need to be focusing on now?
That's a really good question or case study to talk about. So computer science majors are very valuable. Everything's going digital these days, more and more. That's what everything in our society is based on now. So when you have someone who's an undergraduate, I would say start looking early at options like OPT. So optional practical training. As an F1 student, you can get a really good introduction to potential employers. You can start exploring the field. You can start seeing, okay, do any of my friends and colleagues, have they been sponsored for an H-1B or perm? So you can try to get your foot in the door with those types of companies, because that takes some research and time, knowing who to apply to, knowing, am I ever going to get sponsored this way? So undergrads have the luxury of time and starting to plan early. So I would say, make really good grades, talk to your DSO about getting into OPT programs, which may be, you may be able to get the STEM extension for 2 years, even after your program is finished. So that's a good way to find an employer, and then maybe start making calls, talk to, other people, get on Facebook groups and different social media that say, hey, this company is hiring, they're doing H-1B or perms. The other good thing about undergraduates is if you're an F1, you can change to just about anything. You don't have that 2-year residency requirement to worry about. So a lot of people at the college age get married. If you find a spouse during that time in college, that's going to solve a lot of your problems as long as it's a solid marriage. Marriage to a U.S. citizen is a really good immigration option, so you may not have to worry about the employer sponsorship. So I would just say start planning early, keep those grades up, don't violate your F1 status, and look into OPT. Mohammed, I think you're on mute. Okay.
I keep doing this. I'm sorry.
That's okay. I do it too.
So the question here is regarding J1 visas, and it's like the 2-year requirement. What do people do if they want to kind of bypass or get over this 1-year requirement? You mentioned this, but if you want to go over that thing like really quickly, that should work.
Sure. Yeah. So if you're wanting to change your status or adjust and you have that 2-year rule, which a lot of people do, I would say, probably over 75% of people who I've come into contact with in my practice have the 2-year rule. Start looking into if you're going to be able to get the no objection letter or, one of the other 5 reasons why you can apply for that waiver. And you can go and look on the Department of State. All you have to do is type in J1 visa waiver of the 2-year rule, and that's going to bring up a Department of State link, and it's going to go into detail. They actually have a really good website. Sometimes the government doesn't have the greatest websites, but in this case they do. So you can look at these 5 criteria. Let me just repeat those. No objection statement, request by a federal agency, persecution, hardship to a U.S. citizen or spouse, and the Conrad 30 program. So I would say if you're wanting to change to H-1B, you got to do the 2-year rule waiver.
Okay.
There's not really any way around that.
Right. But if, like, again, for this category, exchange scholars, can the scholar himself, herself, ask the host agency that, look, I don't want you to issue me a J1 visa. I want like a F1. They cannot do this, right?
That's definitely up to the sponsoring institution. So They usually don't, and I'll tell you the reason why. The J1 program is always done through kind of what you could call a host sponsor program, which acts as an intermediary to the institution. So when you're dealing with J1 stuff, they probably don't really deal with other types of visas. You may need to go directly to the host university, not the sponsoring program, and see if they have that available. So that's a little bit that's a different question than I was answering, which I would say it's completely up to their HR to do H1B rather than J1, which would be preferable. Definitely, if you can get an H1 over a J1, go for it.
Okay, great. Yeah. All right, wonderful. So are there like best times people should apply, or like there is a website with deadlines, or this, I would assume this depends on the type of visa people are applying for?
It does. So definitely the H1B that are subject to the lottery, those are usually the first couple weeks of March. We're just passing that time frame for the H1B. Those are definitely posted. All other visa categories, just about, you just need to apply for a change or adjustment of status, get all your applications in before you yourself go out of status. So you need to look at your I-94 date, which you can also bring up online. You can type in I-94 lookup and go in get your official I-94 date, which is your authorized stay, and make sure that anything that needs to be filed is filed before you fall out of status. I want to make one point. I didn't mention this about J1 waivers. J1s who are approaching the end of their J1 program, who are considering renewing for an extension, don't apply for your waiver before you get your extension, because it's not going to happen if you apply for your waiver. Okay, so you want to make sure you've exhausted your J1 period of time, even with your extension, before you put in that application for a waiver, because they're going to know your intention is not to comply with the rules, and they're not going to give you that extension if you do it first.
Okay, great. Wonderful. So look, we're approaching, I think we're pretty much perfect on time against all the stereotypes. But we got like a couple of questions. One of them, I got like one additional question. I'm going to read it, although actually I probably might not understand everything as I should. So if a U.S. citizen has a child who's over 21 and is married, and he is on a visit visa to the U.S., can the father apply for a petition for the child while in the U.S. to change status and not need to travel back home until the petition is approved?
Yep, I can answer that. So I will have to pull up the visa bulletin. We might be able to follow up on this one to get the exact time frame, but the short answer is no. Okay, you can file the petition. You can file an I-130 petition, which is the first step in any family case. Okay, but they are going to be in part of a preference category. Kids over 21, or kids that are married and under 21, they do not have visas immediately available. So what does that mean? That means that if they come to the U.S., they would have to maintain status the entire waiting period until they can file for their permanent residency. So if that child, well, I don't want to call them a child if they're over 21 and married, but if that person was here, the parent filed an I-130 for them, and they were students, and they had a student visa for 10 years in the U.S., and by that time they were eligible to apply for a green card, yes, but they cannot apply for it all at the same time like a younger child could, or a spouse or parent could.
All right, that's wonderful. Look, in the last, maybe 3-4 minutes, we're saying that if you have any last-minute recommendations, but I do have one thing after your last-minute recommendations, if you have any.
And we have few questions on the comments. If you have like a couple minutes to, if not, if you have time
through them.
Yeah. If you want to.
Otherwise, you can answer them later on in the comments, like whatever works for you.
Yeah. Okay, yeah. If there are any last minute questions that came through, I can definitely try to answer some of those. And then I did want to talk for a moment about Jana members who, if they call our office, what I want them to make sure that they let us know so that we can give you guys a special discounted rate for your cases. Of course, you don't have to work with our law office. We're more than happy to help you. There are lots of good and qualified attorneys out there. So I would just urge you to speak with a legal representative early on so that you can prepare yourself, whether that's us or someone else. We can take clients nationwide. So let's go ahead and see if we have any more questions you guys want to ask me, and then I'll talk to the members about that.
I don't know if you want to go through these because I haven't, I've been.
Okay, you haven't fielded them yet? Okay.
So maybe later on, I think you're a member on Jana, or at least Abdo is there. We can actually, you guys can respond to these.
We sure will.
Comments. Yeah, you can respond to them directly. But my other question is this, I don't know, you probably don't want to go through this, but I know that when people apply for visas or immigration of any type, there are two types of fees. There is a fee for the lawyer's office, and there's also the government fee thing.
Right.
Do you have like a link for those? Are these available somewhere for people to see? I'm going to share with everybody as you try to answer this question if you want to.
Yes.
This is the contact information for Dr. Lindsey Harris's, law firm office that deals with these things. And this is her phone number. And if you go to this website, the website for the law firm, you can find all contact information, email, everything. And, because Jana everybody knows, because Jana is a non-for-profit organization, we actually are not endorsing or not, everybody works on their own responsibility. Everybody has the responsibility of taking care of their own applications. This thing that has to do with the cost and fees for the government, for the office.
Definitely. Yes. So that's a really good point. There are always two types of fees. There are the filing fees that go directly to the U.S. government, which is typically USCIS or the Department of State. And then there are your attorney's fees for putting together your case and the legal analysis. The best place to find updated fee information is on USCIS website itself. And you have to know what form you're looking for. So if you want to do an I-130 petition for a relative, you can simply type in I-130 with USCIS behind it. Don't go to third-party websites. Go to USCIS, and they will have a filing fees drop-down menu, and you can see what the filing fees are there. That one happens to be $535, but these are all over the place. They get updated regularly. So I would say if you want to check on your own, go through USCIS to check your filing fees, or the Department of State for visa fees. Okay, so those are always different for every case. For the attorney's fees, every time we do a consultation, we will send our clients a follow-up email with a complete case overview and a complete fee estimate. So we'll put in there not only the attorney fee estimate for the case, we do flat fees. We don't like to do hourly. That stresses everybody out. So we want everybody to know exactly how much they're paying. And we'll also list the filing fees so our clients can budget for that and work out a payment plan if they want to. So I would say when we provide our attorney's fees, it's usually right at the end of that consultation.
You also mentioned in the beginning that your office is going to give some kind of discount for people coming through Jana. So this is the best time to say that.
Absolutely. So really special thanks to all the Jana members that were listening today or who may listen in the future if this is posted. We appreciate you guys so much, and we would love to help you out with your case. As a thank you, we want to give half price immigration consultations throughout the month of June. So from now until June, we'll be offering $50 consultations. They're usually $100. That's for a 1-hour consult with either myself or one of the other 2 attorneys at our office, depending on your case type. Also, if you decide to hire our office to handle your case, we want to help the community as much as we can. We're going to do a promotional $250 credit toward your legal fees now through June as well. So please get in contact with us if you have any questions. It's been really nice to talk to you all today. I would love to speak with anybody that needs help. So that's just about all I have for today. Is there anything else you guys want to go over?
I don't have any more questions. I don't know if Abdullah has anything that he wants to add. But before Abdullah says anything, I want to say that we're really, truly grateful This has been very informative for me. I'm sure so many members of our community would really appreciate this and find it very, very helpful.
It's
Really,
really
thank
nice to
you.
have been here. Thank you so much.
Thank you, Dr. Harris, and thank you, Muhammad.
Thank you so much.
Thanks.
Enjoy
Have a
the
nice
rest of the
weekend.
week. Bye-bye. مع السلامة.
مع السلامة.
مع
Bye-bye.
السلامة.
Thank you. Thank you.
أعزائي المشاهدين الكرام، إن شاء الله الحلقة القادمة ستكون عن نفس الموضوع، لكن بالنسبة لكندا. السلام عليكم ورحمة الله وبركاته.